Hello and welcome to Legalese. My name is Vincent Perryman and I'm a local attorney with the law offices of J. Vincent Perryman. Each month, Legalese focuses on a wide range of legal issues and topics. Today's show covers collaborative law. With us now is Susan A. Hinesley of Butler, Sevier, Hinesley & Reed, PLLC. Susan, thanks for being with us today.
Thanks for having me.
The new buzzword that we keep hearing in the legal community is collaborative law, and that this is different to traditional methods of law and may actually be better for practitioners and clients. I guess a good starting place is to ask, what is it?
Well, collaborative law is a new way to approach resolving people's differences. What you're typically used to seeing maybe on TV or through friends and families listening to their experiences with the law is a typical litigation situation. In collaborative law, it allows the parties to actually communicate. It allows the attorneys to communicate more openly and honestly about whatever the differences are. In my case, I do divorce work. So all of my collaborative cases are divorce cases. However, collaborative law is going over into the fields of medical malpractice, which has had some success because doctors and patients who are typically at the very beginning cut off from each other have a chance to discuss, and you'd be surprised at the healing that takes place. And it actually helps those cases. But I focus on divorce and post-divorce litigation.
Okay, and I know from, a lot of practitioners don't even really understand what this is and all of that. And one question that I always get is, well, isn't that really mediation or something like that? How does it differ from sort of some of your regular methods where the court might order the parties to go and speak to a third party in order to mitigate the issue before a trial?
It's very different from mediation. It's very different from litigation in this main sense. On the front end, people agree not to go to court. They sign a collaborative law agreement, and both parties sign it, the attorneys sign it, and it's several pages long, and it details exactly what the process is going to be. One of the main points is you both agree not to go to court. When you take that out of it, it makes people look at a situation differently. There are no motions filed to force someone to do anything. And when you're not looking at going towards court as your ultimate goal, it changes your focus. Now, mediation can be part of the collaborative process. Let's say you get down to the very end and you're just not able to resolve the case. I know a lot of the practitioners here in the Memphis area have agreed that before you would turn the case over to litigators, which is what you would have to do, that you give mediation a shot and go through the mediation process before you terminate the collaborative process. But I haven't had that happen because collaborative has always worked, in my experience.
Okay, and one thing that's always a question, I think, from practitioners and some more savvy clients are, well, is this codified somewhere? But I think really for Tennessee, it's that it's going to be under that initial contract, so it'd be the law of contracts if you were to try and enforce the collaborative agreement.
Correct. And if you're to a point where you're trying to force a collaborative agreement, collaboration has probably failed,
Right.
And at that point you would go to litigation. But I'd have to say that 99% of these cases that go through the collaborative process actually work out in the collaborative process and people don't go to litigation. That doesn't mean that it's easy. That doesn't mean that the two parties get along or, hug at the end of every session or anything like that. It's perfect for a case where you have a lot of assets. It's perfect for a case where maybe one of the parties or both of the parties are in the public eye. It keeps everything out of the public eye. There's nothing filed with the court, and of course court records are part of the public record. So you can go through your divorce quietly without having the outside pressures that perhaps you would have if you were going through litigation.
So I guess a good example of this is I know some divorce attorneys that they didn't want anybody in Shelby County to know of their divorce, so they went one county over and both agreed to that jurisdiction. So instead, they could really do it collaboratively, and then no one would really know anything except for the parties involved in the collaboration.
That's correct.
So now, with the collaborative process, I mean, the main goal of that is to resolve the issue without litigation. Is that correct?
That's the main goal, but underlying that goal is it's not just without litigation. It's also with respect and taking personal responsibility. It forces clients and attorneys to really look at their own actions. Mostly clients. It's a good way for the clients to get more involved in their case. I know that bothers a lot of attorneys. As attorneys, and I'm guilty of this myself, we are very controlling, naturally. And you come to me and I want to solve your problem, and I know what's best for you, and I'm going to tell you exactly what to do. That role is skewed when you're a collaborative attorney. It's centered on the clients. The whole process is client-centered. The litigation world, the whole process is focused on litigation, and it's attorney-centered. So that kind of changes the dynamics, and you see it change when you get into a collaborative session. Maybe the first time you have what we call a four-way session, where it's, if I represent the husband, he and I sit down in a room with the wife and her attorney. There's a lot of animosity between the two people, but you would be surprised what people are able to come up with when they're forced to actually handle the problems themselves with guidance from an attorney, rather than turning their entire problem over to a third party who doesn't really know you.
Right, and it's one of those that I think one of the points there's a couple of selling points that I've always heard about collaborative law, and one is I think it does a better job of, our goal with litigation is to put the parties back in whole monetarily is normally what we're looking at. But with the collaboration, I think we do a better job of not just putting the parties back monetarily, but putting them more back into a normalcy as far as having dealt with some of the emotional issues involved with whatever the conflict is.
And that's the other good thing about collaborative law. As a divorce attorney, and I know 100% of the divorce attorneys that I practice with, a lot of your time is sometimes spent almost being a therapist or a counselor to your client, and that's not typically my role. That's certainly not what I'm trained to do. And in the collaborative process, especially in a divorce, it's high tension. People don't like each other. There have been hurt feelings, and sometimes more so than others. Every situation's different. And in the collaborative, you not only have your attorneys, but you would also have someone in the mental health field that you can call to bounce off your frustrations, that you can call to maybe help you communicate better with your spouse or soon-to-be ex-spouse. Because what we're talking about with divorce are families. People have children. It's not in their children's best interest to bicker and fight and drag children through litigation and drag their children's future money, perhaps college savings, 401ks, liquidate things like that to fund litigation, when there's a better way to do it that might feel uncomfortable at first. But once you go through the process, you have a couple of sessions and you sat down, then you're comfortable sitting across the table talking to your spouse, and you actually get a lot more done than you do going to court and battling each other head to head.
Right. I think it adds the communication factor in there, which is something that we sometimes forget as attorneys, because we
like to as I just shortcutted you.
Oh.
We like to shortcut, I'm like, no, I know where you're going with this, and take over. And it forces an attorney, I think, to really look at their client and really work with the client. And it forces the client to take some responsibility as far as putting their life back together and moving towards the future, and really start, when they're looking at each other across the table and they're both saying they have their children's best interest at heart, but you start having these hard conversations, you would be surprised at the number of people who soften their resolve or change perhaps maybe an unreasonable position when it's just sitting around in a non-confrontational atmosphere talking about their children.
Right. When we return, we'll continue our discussion about collaborative law. Please stay with us.